IRS 135.230 defines family or household member as spouse, former spouse, adult persons related by blood or marriage, persons cohabitating with each other, persons who have cohabitated with each other, or who have been involved in a sexually intimate relationship or unmarried parent of a minor child. For 20 years under Oregon law, an act of abuse against a family member or household member under this definition is considered domestic violence. The 2013 bill also, as we heard, left out stalking as a qualifying domestic violence misdemeanor. House Bill 4145 fixes these two issues. First, it aligns the definition of domestic violence conviction in Oregon's unlawful possession of a firearm statute with existing definitions, as we heard, of domestic violence everywhere else in Oregon law. Second, it recognizes stalking as a qualifying misdemeanor for the same protection as other domestic violence misdemeanors. This legislation also does another really important thing. It requires misdemeanor crimes of domestic violence be reported to the Department of Justice National Crime Information Center so that firearm prohibitions can be properly enforced. It also revises the reporting requirement for the State Department of Police to ensure that attempts to illegally buy a firearm are reported to the proper authorities, and the outcomes of those attempts to buy are tracked and reported so that our system continues to improve. I want to clarify one part of the bill to make sure we have legislative intent on the record, and that's Section 4 of the bill on page 5, line 3. We envision that the Oregon State Police will seek information from local police agencies regarding the status of their response to a denial notice. In some cases, local agencies already respond to these denial notices, and they have received specialized training to respond to those denials. In other jurisdictions, the Oregon State Police is the responding agencies for those denials. So I want to make it clear that the intent of the bill is to create a comprehensive database of the crimes to be used by both law enforcement and the legislature for future policy making. We anticipate that the Oregon State Police will work closely with local jurisdictions and local law enforcement agencies to gather a complete set of data in a manner that puts as little burden as possible on our local law enforcement agencies. The goal is to gain more accurate reporting data regarding the status of responses and investigations from agencies that are responding to them. This is because, as we know, legislation without accountability is not particularly worthwhile. The data portion of this bill will ensure that we have accountability for these bad actors. Attempting to purchase a gun when you're a prohibited purchaser is a crime. You'll find on your desk today a letter from the National Rifle Association, and I want to address a couple of things in that letter. First, they claim that the critical closing of the boyfriend loophole would create a vague and undefined definition of domestic violence. Nothing could be further from the truth. As I said, the provision in the firearm statute directly contradicts Oregon's 20 years of domestic violence definition in our law. Oregon law enforcement, prosecutors, judges, law enforcement, juries have all relied on this definition, and this is a well-settled definition. This change merely confirms in the law what everybody understands as domestic violence and is defined as domestic violence, and that a person who assaults their boyfriend or girlfriend is no less guilty of domestic violence than someone who assaults their husband or wife. The NRA also takes issue with including stalking as an offense under our firearms law. One thing to remember, colleagues, 76% of women murdered by an intimate partner were stalked first. So it is a difficult conviction for a prosecutor to get, and we believe that the objectively reasonable fear that is required to be proven in this law is an incredibly high standard. Thank you, colleagues.